Good morning, everyone, and welcome to the opening plenary session of the ACS National Convention. Please welcome to the stage ACS President Russ Feingold and ACS Executive Vice President Zanelle October.
All right. Good morning, everyone. Good morning. Welcome to day 2 of the 2022 ACS National Convention. We had a pretty incredible day yesterday, hearing from Justice Sotomayor in the afternoon, and getting the opportunity last night to hear from Senator Padilla and Congressman Raskin, and to honor so many extraordinary people and organizations working to make the law a force for protecting democracy and improving people's lives. It was really inspiring.
It really was great, Zanelle, and everybody I've talked to seems to feel exactly the same way, if we might be a bit tired. We hope that today's slate of programming will inspire and challenge everyone here and also everyone who is participating virtually. We do want to take time this convention to celebrate the progressive legal community. But we also want to provide you and its leaders with the information to meet some of these very pressing challenges facing our country, in fact, some of the most pressing and difficult ones in modern history.
Democracy's Moment of Truth. That's not only the title of this morning's panel. It's a theme that ACS is committed to exploring throughout this year. And it's important to keep in mind the full title of that theme: Democracy's Moment of Truth, Succumbing to Autocracy or Forging a Genuinely Multiracial Democracy. The attacks on democracy we are witnessing are disturbing and harken back to Jim Crow era tactics. Restrictions to ballot access, extreme racial and partisan gerrymandering of congressional and state legislative districts, and an explosion of voter suppression legislation by states. And the most stark and visceral of all attacks on democracy, the January 6th insurrection. And as the January 6th Select Committee is proving, the threat to our democracy from those behind the January 6th insurrection is acute and ongoing, with efforts currently underway by proponents of the big lie to subvert future elections.
And it really should come as no surprise to those of us who have been paying attention that these attacks would kick into high gear and find success now. These threats to democracy have been enabled by the rights packing of the Supreme Court and the conservative supermajority's decimation of the Voting Rights Act and blessing of state efforts to gerrymander electoral maps and unleash dark money into our elections. This packed court has proven itself hostile to constitutional rights, to racial equity, and to the safeguards of democracy. To restore the court's legitimacy and to protect constitutional democracy, we must reform the Supreme Court.
ACS is so outspoken about the need for Supreme Court reform because it directly relates to nearly every legal challenge we are confronting right now. In the absence of court reform, this conservative supermajority will continue to rewrite our laws according to its ideological agenda, advancing the interests of the white and powerful. This is not about party. It's about safeguarding our constitutional democracy. If we're talking about reproductive rights, voting rights, racial equity, we have to talk and achieve Supreme Court reform.
We are already engaging elected representatives in the House and the Senate to support court reform, and I encourage all of you to include the need for Supreme Court reform in your conversations about the pressing legal challenges we are confronting right now. As I said last night, it is easy to get disheartened, but as lawyers, there is so much we can do. Lawyers of good conscience are a key component to getting this country back on the path toward a genuinely multiracial democracy. And it's not just voting rights experts or civil rights attorneys and the like who help us on this path, as important as they are. It is also lawyers who practice in administrative law, bankruptcy, tax, consumer law, and a host of other areas. It's advocates and students as well who are engaging voters, the public, and our elected officials each and every day. We're all needed in this effort, and ACS is a resource in your efforts.
Our elections are under attack. You can do something about that today by taking our poll worker pledge and serving as a poll worker in your state during this year's election cycle. In many states' efforts are underway to install proponents of the big lie into offices that oversee or are meant to protect election integrity. Our Run, Vote, Work initiative encourages our members, you, particularly those who have been historically excluded from these positions, to consider running for down ballot or local offices that serve a role in protecting our elections. This includes secretaries of state, state attorneys general, and state court judges. You can find more information about Run, Vote, Work and the Poll Worker Pledge at acslaw.org. Whatever we do, we need to do it now. This can't wait until 2024 and the next presidential election cycle. The far right hasn't taken a break in its efforts to subvert democracy, and we can't afford to take a break in our efforts to protect it.
So now it's my pleasure to introduce the moderator for our first panel of the day, Sylvia Albert, Director of Voting and Elections with Common Cause. Sylvia has more than a decade of professional experience in public interest law and public policy campaigns, expanding ballot access, reducing barriers to participation, and combating voter intimidation among historically disenfranchised communities. She's the perfect person to lead this morning's conversation, so please join me in welcoming Sylvia and the rest of the panelists for this convention.
Thank you so much. Is this on? Okay, great. Well, I'm so excited to be here. This is really full circle, as I remember so distinctly. Then Professor Peter Rubin in Crim Law Class 1L year talking about ACS and what he wanted it to be. And so I'm so excited to be here. I'm not going to say how many years later to see that we are still fighting the good fight. All right, before we get to the panel, I will do the nice housekeeping rules. So everybody please turn off your cell phones, or at the very least, turn them to silent. If you would like to tweet, please use the hashtag ACS2022. And to receive CLE, you'll need to submit 2 codes, which I will provide, once at the beginning and once in the middle to make sure you don't run away. So first CLE code is barbecue. And I'll give you the second one a little bit later. And you should see on your tables index cards to write down questions. We will have plenty of time at the end for questions, so fill those out, hold them up, and an ACS staff member will come around and get that from you. All right, so I think everybody here knows where we are, but let's set the stage. We saw record turnout in 2020, followed by a rash of anti-voter bills, questioning results and lack of confidence in the election. Election deniers are running and winning positions which control elections. Congress seems to be at an impasse in doing anything in the Voting Rights Act space or even the Electoral Count Act space. Millions, I think last I heard 70% of Republicans continue to believe that the president did not win the election. And on January 6th, violent mob tried to overthrow our government. And those people are also part of the group that is running for and winning at local races. So today we'll be hearing from our distinguished panelists on what we can do to protect the right to vote and election integrity. How did we get here? How do we compare with the rest of the world? And really, where do we go? So I'll introduce our panelists, and then we will get started. So to my left, Professor Guy Charles is a professor of law at Harvard Law, where he also directs the Charles Hamilton Institute for Race and Justice. He writes about how law mediates political power and how law addresses racial subordination, and was recently appointed to the Presidential Commission on the Supreme Court by President Biden. Elizabeth Anderson is the executive director of the World Justice Project, leading its global efforts to advance the rule of law through research, strategic convenings, and support for innovative programs. She's an expert in international human rights law, international criminal law, and transitional justice. And last but not least, Raheem Brooks is the president of the Alliance for Justice, a 130-plus member organization advocating for a stronger democracy, including fair and more accessible courts. He clerked for Justice Cameron of the Constitutional Court of South Africa and on the 9th and 10th Circuits, and litigated the CFPB's constitutionality, representing Senators Whitehouse, Blumenthal, and Hirino, while working at Sussman Godfrey. Thank you so much, panelists, for joining today. Okay, so first question, and not an easy one. How did we get here? Why were we set up as a nation to be so susceptible to this attack on democracy? And I'll start with you, Professor Charles.
Sure. Well, it's a pleasure to be here. And of course, the circumstances under which we find ourselves are extremely difficult for a polity that considers itself to be one of the premier, if not the premier, democratic polity in the world. But I think there are a couple things that are worth noting at the outset. First, the experiment that we're trying to do in the 21st century, a truly multiracial, multicultural, multi-democracy, is really a new one for the modern world, right? This polity, this country, was not intended to incorporate and understand and see people who are different as full members of the community. And so it has evolved and is in the process of evolving into that type of a polity. But when you look at our constitutional structure, so this is the American Constitution Society, so let's think about the Constitution. We have a Constitution that is actually not very reflective of the type of democracy that we want to have. So if you look at the Electoral College, if we started and was starting anew, no one in this room and very few people in this country would actually create a system of representation that takes as the Electoral College its model of how we do things, right? We wouldn't devolve so much power for a central entity, for the national government, to the states and to state officials. So in many respects, we have a very decentralized system. We don't have a positive right to vote. We have a Senate that is not representative, right? 500,000 people in Wyoming have the same amount of power in the Senate as millions of people in California. We have a gerrymandered House. We don't have a system in which we have federal officials at the federal level running federal elections. So it's like going to the hospital and you get in and the person who's doing the intake is grandmama from down the street, right? That is not precisely, you wouldn't have much trust in that type of a process. We have partisan administration of elections. We have a Supreme Court that no longer really believes in its role in upholding democracy. We have a Congress that is sclerotic, and we are divided bitterly as a country. So it's no surprising then that you have a process in which a mob of people attempted to subvert a federal and national election. We have a constitutional structure that is not fit for the type of 21st century democracy that we aspire to be, especially given the type of people that we are. So if we had to do it all over again, this is not the way that we would design our democracy. We would probably have a positive right to vote inscribed in our Constitution that is tied to national citizenship. And that wouldn't be tied to state citizenship, which means that if you are a citizen if you're living in Puerto Rico, even though you are a citizen of the United States, you don't have a right to vote. Or of course, we know that if you live in DC, well, forget about representation in the Senate, right? So we wouldn't tie it that way. We would have a positive right to vote. We would probably have a central system that administers federal elections. We would have a dispute resolution mechanism. We wouldn't depend upon the states and partisan administrators to determine what happens in our fundamental and crucial elections, right? So our system of administering elections, of protecting the right to vote from a constitutional level is deficient, and I think in many ways that explains how we've gotten here. And I haven't even talked about racial divisions and other types of subordination that is layered on top of, both as a matter of history and as a matter of present-day practice, that is layered on top of the rickety framework that we currently have. That's an initial bit into how we got here.
Thank you. Betsy.
Okay. So first of all, thank you so much to Zanelle for inviting me and Sylvia for the introduction. It's great to be here. My organization, the World Justice Project, works to advance the rule of law around the world. So we work in over 140 countries, including the United States. And we're putting increased focus on the United States. And so it's a particular pleasure to be with you all here for this conversation. I would add two things to that excellent first response, putting all of this a little bit in global perspective. One is that I want to debunk the idea that there is some perfect model or system that we could get the design right for all time. What we know from working on advancing the rule of law in partnership with colleagues all over the world is this is a never-ending project. And it gets harder sometimes. I think we're in one of those moments, but that's really why an organization like ACS exists, to do that ongoing work. The second thing is to really situate what's going on here in the United States globally. So what we are experiencing here in the US is to some extent unique and particular to this context, but it is also very much a part of global trends that we have seen over a decade and a half at least. The World Justice Project gathers data around the world. We survey lawyers, practitioners, and households. We're quite interested in understanding not just what are the laws on the books, the institutions in place, but how are those working in people's lives. And so we survey every year over 500 questions, over 100,000 people all over the world. And then based on those surveys, score countries on different factors of the rule of law and rank them. And what we see in that data is a persistent decline, at least over the last 5 years, with more countries declining on most measures of the rule of law. And certainly that's been holding here in the United States, where the US has declined in all factors of the rule of law, with the exception of regulatory enforcement over that 5-year period. We also measure constraints on government powers, corruption, open government, fundamental rights, order and security, criminal justice, and civil justice. And in each of those measures, the US has been persistently declining. These are part of global shocks that we've seen to the rule of law, I believe. We had economic dislocation from globalization and from the Great Recession, which has exacerbated inequality and created backlash against democratic governance in many contexts. This has been exacerbated by disinformation and the challenges posed by social media and its misuse and abuse by autocrats. And then, of course, the pandemic effect was an additional shock over the last 2 years. So we had seen in our data over 4 years, from 2016 to 2021, roughly 50 to 60% of countries were declining in their overall rule of law score, including the United States. Between 2020 and 2021, in the pandemic year, it was 74% of countries saw a decline in the rule of law, and that accounted for 85% of the world's population lived in a country where the rule of law was declining. So the US is very much a part of that global trend. In the United States, where we've seen the sharpest declines, and this I think dovetails with some of what Professor Charles said, have been on constraints on government powers, the checks and balances that are imposed on the executive by the legislature, by the courts, by independent audit agencies, by civil society, all eroding over this period, and also declines in our measures of fundamental rights. So there's information about all this data I think in the app that's accessible, and I've got some hard copies up here too if folks are interested. And we can get into the details in the next round.
Thank you, Betsy. Oh, that was such a happy thought. Raheem.
That's a good segue for me. When I was headed over here, I told my partner that I was coming to have a great panel with all of you, and he said, "What's the topic?" And I said, "The death of democracy." and he said, "That sounds like a really fun group of people." And I told him, "You all are my people. This is a serious conversation that needs to be happening now," and I'm grateful to my co-panelists for those introductions. I think as serious people, we have to start off by saying, when we say, how do we get here, it assumes that there was a there ever. And the truth of the matter is, I think most of us know there wasn't a there. We've always kind of been here on the precipice of authoritarianism. What do I mean by that? I mean to say that when a public official can publicly execute a person while being recorded by kneeling on their neck for nearly 9 minutes, we're pretty close to authoritarianism. We remind ourselves that that wasn't the first time someone was executed while being recorded. Eric Garner, of course, had the same thing happen to him several years before. We're not very far from authoritarianism. When we imprison nearly 2 million people in our own country, nearly 20% of the world's prisoners exist in the freest country on earth, we're probably not very far from authoritarianism. And in fact, when the Supreme Court rules in what seems like a few short weeks that women and other people capable of being pregnant no longer have control over their bodies, we're probably not very far from authoritarianism. So I start by saying that to just make the point that in fact, the United States is always walking a tightrope between its hopes and its aspirations for what it might be and the actualities of the lived experiences of people who were not initially read into the original document, but over time have gradually been incorporated due to the hard work of institutions like ACS and so many of the ones that you work for. So that's just to ground us, right? We are where we are because we've always kind of been here. The question really is, how have we come so close to finally falling over the cliff? And to me, the answer to that is really about what can only be described as a white populist political movement in our country that has existed from the very beginning. The question always, though, is, and this we can get into some more in the next question, is where does that group of people and that idea sit in the body politic? And my basic view is that at every moment in our history, starting from the Civil War forward, I'm not a historian, so I won't give you a long lesson, but rather, one of our major two political parties is always flirting with power and flirting with that group of people, right? Initially, it was the Southern Democrats, known as the Dixiecrats. Eventually, it's Richard Nixon, who, of course, we could honor today since the history of the Watergate break-in, the anniversary, and his Southern strategy. And what we found in 2016, when one of our major political parties, I know it's not supposed to be political, so I'll just refer to them generally, one of our major political parties was flirting with an authoritarian candidate. There was insufficient political resources in their party and in the country as a whole to resist that person. And in fact, then we went several years of that same party cooperating with this president, and though they knew full well that all of his instincts were quite authoritarian and leading us in exactly the wrong direction. And since we're at the ACS convention and I represent the Alliance for Justice, one of the major pushes that allowed for the kind of unison between President Trump and the Republican Party was to place as many judges as possible on the federal bench who represented a particular ideology, again, in furtherance of an overall conservative agenda, an overall power-laden agenda, but willing to tap into the worst instincts of our society. And so for me, the answer to how we got here is that we as a country have still not exercised this fundamental demon, which is populist white supremacy, excuse me. Sometimes, as I like to say, it's more supremacist, sometimes it's more populist, but it's always white, right? So at its core, our major political parties have got to decide to deal with this element. And we shouldn't fool ourselves as progressives in thinking that it can't infect our party at some point, right? When we decide that we're tired of being in the minority and we need to control the government in one way or another, that group of people will always be sitting out there flirting with us in one way or another to suggest that they are the gateway. And until Americans decide that that is an unacceptable way to proceed, we will never move past this precipice of being so close to authoritarianism.
Thank you. Great. You guys all brought up some really great thoughts. I want to get further into the what you were saying right now about the history of racism in this country. We like, as you said, we like to imagine that we live in the freest country and that the rule of law is strong here. But really, what is it about racism that has, over time or consistently, undermined the rule of law in America? Like, where is it? How is it rooted?
Should I start?
Yes. I'm sorry.
No worries. I just figured I had just been on that on that horse, so I might as well take a break. But I think that it is our greatest hope and greatest curse that we are a hopeful people. We are inclined to forgetfulness. And so it seemed to me that only in the United States of America could we elect our first black president and immediately say, okay, let's stop talking about race. Though, of course, he was going to be the physical embodiment of race every day leading the country. I mean, that is a weird kind of association. It'd almost be like anyone in the room marrying someone of a different religion, a different race, and suddenly, as soon as they had done so, saying, okay, you're not that thing anymore. Let's talk differently. I'm going to live with you as though you are something other than what you are. And so for me, it's actually that return to historical amnesia consistently, though we have every bit of evidence to the contrary that we've escaped this sort of racial paradox or the original sin, however you'd like to describe it. So as soon as we elect Barack Obama, we immediately have the Tea Party. As soon as we have record voter turnout, right, the greatest number of people in the country voting of all races, we immediately have several restrictive ballot laws and measures that take place throughout the country. And again, as I said, motivated by that populist white supremacist group, but not alone, in concert with others. And so I think it is who we are. There is no escaping it, to use Eddie Glaude's phrase, right? This is who we are. And so it seems to me that ultimately what we've got to assess is, okay, recognizing who we are, recognizing that we have, I joked with the panelists, like, America has herpes, right? That's what racism is. It just kind of flares up every once in a while. We try to suppress it, but it lies dormant in us. America just has herpes. And we've ultimately got to cure ourselves of it one way or another. I'm just trying to make light of a serious thing early in the morning. But we've got to cure ourselves of it one way or the other, but it doesn't work if we constantly ignore it and act as though we don't have it because it hasn't flared up recently.
Mm-hmm. Professor Charles, would you agree that we're in a flare-up of herpes?
I'm going to leave the amazing analogy to folks who are really good at thinking it through. Yeah, I mean, there's a lot to be said for looking back at our history, and obviously a country, right? If you look at the preamble to the Constitution or the Declaration of Independence, or you think about, look, who was this country founded for, right? So we the people really just didn't mean all of the people sitting in this room, right? So we could talk about race, we could talk about class, we could talk about region, we could talk about gender, we could now bring in sexual orientation, right? We could think about religion, right? But a country that was explicitly founded on a compromise with slavery, right? It's in there, in the founding document, right? In the DNA, right? So, of course, and when you look at the history, it is recent history. Right? There's a tendency to think about the race questions in this country as past, right? So, or to put it differently in the terms of the Chief Justice of the Supreme Court of the United States, right? That history has changed. Well, some of it has, and some of it has not. And so the compromises that we've always made with slavery, right? Every single time it comes up when the question is, all right, how do we deal with the question of fundamental equality? Well, we compromise on that question, whether it is slavery, whether it's a civil war, whether it's the post-Civil War resolution, whether it's even the 1965 Voting Rights Act, right? We love the 1965 Voting Rights Act, but if you look at what the black radicals wanted, they wanted something much more profound than what they actually got. Right? The 65 VRA that we revere today is a compromise. It's a compromise between what our aspirations were and what the reality on the ground was. Right? So we are always compromising around this question of fundamental equality. So of course it rears its ugly head. But then you layer that on top of a structure that is very rickety. Right? So you layer it on a structure in which partisans control many parts of the process. So that makes it easy for people to exercise their racial discretions. You layer it on a structure in which you depend upon the court or courts to vindicate fundamental rights. And if they believe that voting is a privilege as opposed to a right, if those are the folks who control the process, then you're going to get a very different type of an outcome. Right? So you have to take both the history and the structure, and you have to tie them together. That explains a lot of where we find ourselves and why we continue to struggle. Right? Now, I think there's progress. One has to admit that there's progress, but there's also struggle. And I really love the way that you put it, that it is always an evolving process. Right? There's never a single resolution.
You know, the U.S. is a multiracial society, and as Mr. Brooks said, you know, we've never had, you know, real rule of law, but it's just that the white part is now kind of falling into that line. How do we compare, Betsy, with other places who are, you know, maybe more homogeneous? And is this something that would happen regardless of where humans are? You would find a way to divide each other, or is this a reflection of our racial history?
Well, certainly, I would agree with my co-panelists that this is, you know, the history of racism in this country and the kind of foundational flaw in our structure has really held us back in the rule of law, and it shows up in our global data. So the U.S. in our data ranks 27th out of 139 countries that we looked at last year, and has been falling. And that recent decline has, as I mentioned, been a function of the decline in our scores on constraints on government powers in particular, some of what we saw around the last election and so on. But what really holds the U.S. back, what puts us at 27th rather than 7th or 1st, as we I think might sometimes fancy ourselves, is this foundational flaw, is racism in our system and in the way it operates in people's lives. So what's really striking in our data when we ask questions of people about how they're experiencing the justice system, and then we develop scores on discrimination in the civil justice system, for example, the US ranks 122nd out of 139 countries. So that's not just countries that are homogenous that are doing better than us. It's also other very diverse places that are doing better than us. When we ask questions that go to scores on impartiality of the criminal justice system, the US ranks 111th out of 139. On affordability and accessibility of the civil justice system, the US ranks 126th out of 139 countries. So there's clearly some very important fundamental work to be done on these issues.
What you were saying, Professor Charles, earlier about the VRA, that it makes me remember that when I was in college, as I'm going to date myself, I was at Berkeley, and people there were so sad that they missed the civil rights movement. They really wanted to get out there and protest, and they're so sad that they missed it. So while we were all celebrating the VRA and the end of the civil rights movement, what did that allow to happen in the last 30, 40, 50 years when we thought everything was fine?
Yeah, I mean, so this is the part, again, to go back to something my co-panelists have both said about the progress and regress. Right, so you get the Voting Rights Act, and then at some point in time, somebody says, though that started even at the very beginning, but at some point in time, somebody says, well, gee, enough is enough. We've made enough progress, that's enough. The country makes a small concession to its fundamental inequality in education, right? And at some point in time, somebody says, well, this small concession that we're calling race-conscious affirmative action, right? This minor concession layered on top of structural inequality in which kids of color, Black kids, are getting substandard education, and in which the present effects of de facto and de jure discrimination still lives with us, right? But that small concession, people say, you know what, that's too much, and really that's going to end. And then the question is, when are we going to make peace with the principle of equality, which is being defined very narrowly as colorblindness? And you see a court that more than likely this term is going to say to that small, tiny concession, no, it violates our fundamental principle of colorblindness and equality. And you could go down the line, right? So a power that Congress has exercised for almost 50 years in terms of voting rights, the court says, well, Congress no longer has that power anymore. Wherever racial progress has been made, and it's been relatively narrow, right? Relatively narrow progress, there's a fairly strong backlash as to an attempt at retrenchment. So for those of you, because you're younger than I am, who believe that you missed the civil rights movement, you are lucky that you are now in the midst of a reconceptualization of where this country is going, right? What is our fundamental commitment to a set of norms and questions around equality, right? And you could take all of your equality categories, all of them are on the table, right? What are our conceptions to democracy? And you could take our fundamental commitments to democracy, whether it is money in politics, or the right to vote, or the role of state legislatures, right? All of them are now on the table. So for people who thought they missed their moment, well, history has now blessed you. This is your moment to now have an impact on restructuring the future with an understanding that whatever compromise is made, the next compromise, there's still going to be a push and a pull to bring it back, progress followed by retrenchment.
Mm-hmm. And those, the progress followed by retrenchment that you speak of is clearly seen in our court cases, right? Everything from the 70s is desegregation, yay, and then the 80s into the 90s is, oh wait, no. Raheem, how is the way that we fill our courts, and with the people that we fill our courts with, how does that lead to such large swings in our progress and lack thereof?
Feels it's a big question. I don't know that I think of it as having large swings. I mean, over the course of a large span of time, yes, but I'm only 35, so it feels like a relatively short swing for me. The way I tend to think about it is, after the civil rights movement, our organization was founded with, as many progressive organizations were, with the Powell memo in mind. So, you know, before he became a Supreme Court justice, Lewis Powell was a major figure in the Chamber of Commerce and wrote a memorandum to the business community essentially saying, you know, the blacks, the gays, the poor, women are taking over the society, and we've really got to do something about it if we're going to defend American capitalism. That's the Cliff Notes version. You should read the full memo. So, and that part of that entire project was to reclaim the courts. And we are now seeing, after roughly 40 years of intense focus from the right on the courts, their defining moment. They have had large majorities on the court before, but never so conservative a majority as we have today. I often say to my staff, this is the bottom, because that's the cheeriest thing that I can say to give us the sense that we are moving forward towards something else. But now that they have that majority, one would have hoped, and this goes back to our conversation about the erosion of democracy, one would have hoped that they would exercise a degree of caution, some modesty in the fact that they now have a majority that allows them to do what they would like to do over a period of time. But of course, they've rushed ahead, and if the Dobbs decision that was released is in fact close to the final decision, totally eviscerated the doctrine of stare decisis. Most of us have walked around thinking that the law proceeds in a somewhat orderly fashion, and that in fact when you want to overturn a precedent, particularly one as old as Roe, that you've got to have a bunch of good reasons. In fact, they gave us this 4 or 5 part test that you would use in order to identify whether or not you could overrule it, and you read Justice Alito's opinion, you're like, where's the law in this opinion? I thought this was the Supreme Court. And that, I think, is one of the scariest things about what we're confronting, just to drive everything together for a moment, which is my understanding, and Betsy will know this better than I will, is that one of the fundamental sort of indicators that a democracy is failing is the capture of the courts, right? Because you take the courts, which have the legitimacy in a society of providing legal pronouncements, and have them start to pronounce things as legal that the society broadly as a whole would otherwise consider to be beyond what would be acceptable. And so I think we're beginning to see the first phases of that over time. The West Virginia v. EPA case will likely be another indication of it. And so we can't fall victim to thinking, well, this is the Supreme Court and this is the law, right? We all, most of us in this room, have been trained as lawyers. When you feel as though the law is not being dutifully applied in the way that you were taught it ought to be applied, there is reason for concern and to resist the system in ways that make sense. And we can talk about what some of that might look like, but ultimately, one of our best tools is ensuring that we appoint people who share our values to the courts as quickly as possible.
Betsy, can you talk to that? What is the implication of the loss of the courts, and what do we see worldwide?
Yeah, well, Rakeem is exactly right. That's kind of the autocrat's playbook that lots of people have written about and has been studied. We can see it unfolding in places like Poland and Hungary over the last decade, where I think there's kind of 2 key tactics. 1, capture the courts. 2, capture the media. And what's challenging is when that's done by legal means, right? Not extra legal means. So it's much more difficult to combat in those contexts. So I think the kinds of strategies that Rakeem is describing here are exactly right. I would caution, however, kind of overclaiming, or and we may disagree about this, but I think it's right for discussion. But I'm anxious about asserting in ways that are maybe too sweeping that the courts are no longer legitimate because they've been, stacked or captured, maybe in ways that we think are a little bit unfair or gaming the system. Because I think if we head down that road, then the institutions and the vehicles that are most likely to save us in a crisis have been undermined and delegitimized. And so I think that's really scary to think about. And we asked questions about this in our data collection. In our survey a year ago, May of 2021, we asked a nationally representative sample of households here in the United States to which of these statements they agree with. And it is important to obey the law no matter who you voted for. That's statement 1. Or you don't have to obey the government if you didn't vote for them. And what was striking is that still a lot, notwithstanding January 6th, and what we see sometimes in polling about whether people believe that President Biden was lawfully elected, that still 78, 79% of people said, agreed with the rule of law answer there, that it's important to obey the law no matter who you voted for. Now, you'd like it to be 100%, but 78 or 79 is not terrible. Only 8% disagreed with that statement. And and then there were others who, 13% said neither, so that's a bit of a wild card in there. But what's really most striking to me in this data is virtually the same number of people agreed with the rule of law statement there who were Republicans as Democrats. It was 78% of Democrats, 79% of Republicans said you have to follow the law no matter who you voted for. And I think that's maybe a little note of hope to hang on to. We still have a vast majority that believes in rule of law, and I think we need to build on that, make that law work for everybody.
We interrupt your regularly scheduled program to tell you that the second CLE code is OCEAN. OCEAN, write that down. Thinking about the Supreme Court, I am sure, as many of you were, am often 10 a.m. on SCOTUS blog watching decisions come down. And as a lawyer, I'm always happy when I see a very weird mix-up, right? It's a Barrett, Gorsuch, Kagan, Sotomayor. Like, wow, that makes me feel like we haven't lost the courts, in the sense that, these big ticket items that we all care about are places where we see these vast, splits. But when you get down to, as you were saying, the regulatory rule of law, it seems that there's still cohesion there. And I wonder, as you were saying, if we talk about it like it's lost, then maybe, we are going to, force it to happen even faster.
Can I add one thing to that? When I was clerking on the Ninth Circuit, I remember that one of the happiest moments was that as President Trump started to enact things like the Muslim ban, it seemed to be, it wasn't exclusively, but several times there were Bush-appointed judges who were limiting his ability to do so. I think what I'm most concerned about now is whether or not the most recent spate of McConnell-Trump judges will act in the way that the Bush judges did. And what also causes me concern trying to prepare for this panel and reading up some is it sometimes feels like it's out of our hands meaning the progressive side. The question really is whether or not the conservative parts of our society will respond and check themselves in their agreement with as I said, the sort of white populist groups or the authoritarian groups. And so I very much agree that it shouldn't be a competition over the system, who has control over one side or the other. But it feels as though the best thing that we can do is ensure that the people that we believe are most likely to uphold the rule of law are appointed, while simultaneously figuring out somehow holding our breath and supporting the Liz Cheneys of the world on this particular instant as they resist the worst elements of our society, the most authoritarian elements of our society. But I very much agree with you that it doesn't feel as though the entire system is captured, but Trump did appoint 1/3 of the judges. And the question is, what kinds of people are they? And are they closer to the Bush era judges, or are they closer to something else which allows them being the authoritarians, to enact a new political project?
Do you mind if I ask that to your question?
Sure.
Sorry to put you on the spot, but I'm going to. Do you have, from the work that you've been doing, the data, do you have any thoughts on how does one uphold sort of and reinforce fundamental norms and principles, right? So one of the major worries from the Trump era was the erosion of norms and principles. And part of what was really striking about January 6th, but also watching the hearings, and this goes to something too that you just said, Raheem, which were some of the lawyers, including watching Mike Pence's lawyers, saying, no, we cannot do that. That is wrong, that is illegal, that is inconsistent with the law, right? And that's important, and that's to be applauded, right? So how do we uphold norms and laws across the bipartisan frame, while at the same time attempting to address sort of asymmetries between the parties, or asymmetrical use of misuse of norms, or departure from norms, whether that's departure from precedent, or whether that's departure from rule of law norms, right, or other types of institutional norms, say in the Senate, right? So do you have a sense of how one can both reinforce legitimacy while at the same time calling out illegitimacy without undermining the type of long-term legitimacy that one wants to hold on to?
Yeah. So this is actually, in some ways, the challenge that was the impetus for founding my organization, which was initially a project of the American Bar Association, the then president of the ABA back in 2007, really thought, we talk about the rule of law, but it's a slippery concept, and a lot of these norms are also kind of slippery in that way, and that's dangerous. So we need to actually articulate in clear and measurable ways what this is. And so that was really the impetus for the World Justice Project to develop a kind of universally resonant definition of the rule of law, which is largely what the UN has articulated, what the rule of law is, what it requires, certain elements of it, and then find a way to measure it, and then socialize that. And that's work we continue to do, and we love Common Cause with ACS and lots of others to do so, because I think it is a multi-stakeholder effort. It can't just be lawyers and judges who take responsibility for this. It has to seep into society broadly. I think civic education and civics education is critically important. I think really working closely with the media to cover rule of law topics responsibly. One of the things that we're really troubled by is when people use rule of law language, which is to justify, validate things that are by no stretch of the imagination rule of law actions. So there were those famous robocalls that went out on January 6th by the Republican Attorney General's Association Rule of Law Committee that was calling on people to march on the Capitol. And to defend the rule of law. That was obviously not rule of law action, and that needs to be called out and contested. And really educating the media and pushing them to cover these things responsibly, I think, is also really critically important.
Let's continue on that theme. So we've talked about how we got here and where we are, and not great. How do we move forward? How do we fortify our democratic institutions? How do we make sure that there is a democracy to speak of in 10, 20, 30 years? Professor Charles?
Oh, thank you. I didn't pay you enough, did I? All right, so there are a couple things that I think are worth noting. First, we are starting to see, particularly in states that are largely controlled by Democrats, but not exclusively, that states are an important site of not just contestation, but also of progress, right? So in many respects, some of the places where we are today, the types of voting changes that we have today are indeed remarkable. So we have same-day registration in a vast majority of states. We have rules that make it easier for people to vote, whether it's mail-in ballots or early voting or automatic registration, right? We have states that have taken the question of gerrymandering very seriously, and whether it is through bipartisan or nonpartisan commissions or state Supreme Courts that are enforcing their state constitutions on political equality, right? So we are seeing places where there's hope, and not just hope, but actually developments that really do matter. And I think continuing to take those developments, we have a system in which we say states are laboratories of democracy. Well, I mean, right, there's supposed to be an experiment, you're supposed to learn from it, and you're supposed to implement it. And so this is, in some respects, we are in that process. So if I were to point to, and I could come back and talk about some other things, but if I were to point to places where we're actually seeing progress, that's one of the places where we are actually seeing progress. And some places maybe not as much as we would like to. I'd like to see, for example, the state of New York do a lot more than it is doing in terms of modernizing its election rules. But we are seeing progress, and we are better off in many respects today. So 40 or 50 years ago, many states, about 17 states or so before the advent of the Voting Rights Act, had literacy tests. right? There are some things that are no longer on the table, so we're not fighting about literacy tests. We're fighting about same-day registration. We're fighting about gerrymandering, and those are good things to fight about, and we are seeing progress in many states, and I think we ought to celebrate that progress and figure out how do we take the progress that's happening in some places and move it into other places where the same type of action is not happening.
That does remind me that today, or yesterday, I believe, the Massachusetts Votes Act passed both houses, and hopefully will be going to the governor's desk. And that is a place where people tend to think that strong democratic states are bastions of great voting policies, and they are absolutely not. So they are a place that we might be able to get some wins that can start start a tidal wave, maybe. Rakeem, what do we have to do to fortify our democracy?
I'll take this as a point of personal privilege since I work for an organization that has a set of campaigns that we think are important to democracy. So like ACS and our partners at the Leadership Conference, the Alliance for Justice really believes we have to fill every federal vacancy. You all are the perfect audience for that, which is why I'm reminding you of it. Our democracy stands on three legs, right? The executive, the legislative, and the judicial branch. And I think part of the reason we're falling down a bit is because, as a whole, the left has not been as strong on one of the legs of democracy, that being the judiciary, and you all are the perfect messengers of that. So please do be in touch with your senators, encouraging them and the Judiciary Committee to move as quickly as possible. I feel badly saying that. We sent out a message saying that the president had nominated and confirmed more people since Kennedy. That's all true. He is moving very, very quickly, but they have to move more quickly still in order to make sure that we don't leave vacancies, because Republicans and Mitch McConnell have already made clear what they will do if, in fact, they retake the Senate. They won't confirm a single judge going into the 2024 election, and we really, the justice system as a whole can't handle that, but in particular, we can't deal with the consequences if they should regain power such that they appoint more people in the same vintage of the three justices that President Trump appointed most recently. The second focuses on states and our state Supreme Courts. Some are elected, some are appointed, but as you know, the state Supreme Courts have been responsible for handing democracy a series of victories with regard to redistricting. And so it's vitally important that we remain focused on them. Conservatives have started to encircle several of the courts, Pennsylvania, Michigan, Ohio, North Carolina, places that they think can be obstacles to them in 2024. And as a consequence, we've got to remain laser focused on ensuring that those courts remain pro-democratic, period. Not necessarily pro-big D, but pro-small d, democratic, whatever that takes. And finally, we've all probably, with rapt attention, been paying attention to the January 6 hearings, increasingly Ginny Thomas's involvement with the insurrection. I think since, again, it is the anniversary of Watergate, we have to be intensely focused on learning more about that. We ought not jump to conclusions, because we may lose the majority of society if we seem to have prejudged what's happening, but I think a lot of us are concerned that one of our sitting justices may have known a good deal about this and even ruled in cases where he was conflicted. So I think it's important that we remain focused, and when the time comes, if the time comes, call for further hearings into Ginny Thomas's and Justice Thomas's involvement in the insurrection.
Betsy?
Well, that's a good segue to the point that I would add, which is really about just reminding us that we often think about the institutions and the laws, and there's lots of work to be done to reform and strengthen those. But when it comes down to ultimately is individual actors who take decisions and act either with integrity and respect for rule of law principles or not. And there needs to be accountability when there is when people take the non-rule of law path, and there also needs to be celebration of those who take courageous steps when they're placed in a really difficult, often even life-threatening position, and have to take a decision often against personal interest, but to uphold our democratic principles. So, and this is again underscored by the data that we collect. So one of the drags on the US rule of law performance in recent years has been around constraints on government powers, and specifically when we ask people about whether people in high places will be held accountable. Increasingly, Americans are pessimistic about that. And which is really fundamental what the rule of law is about, whether the same laws apply to everyone, no matter their status in society. So, for example, a year ago we asked, again, representative sample of Americans, whether they thought if a high-ranking public official were found to be taking public funds for personal profit, whether they would be held accountable. And only 24% said that they would be held accountable. 64% said they thought that an investigation would be opened, but it wouldn't go anywhere. And 12% said that nothing would, the allegations would be ignored. And when you think about that, of course, recent experience underscores those perceptions of Americans. So we need to turn that around. There needs to be accountability at all levels of government for misconduct, and the January 6 hearings are a good step in that direction. Needs to be followed through. But we often think about accountability only in criminal justice terms, and this is a trap that I think we fall into a lot globally, internationally. We're seeing it right now in Ukraine with the absolute fixation on the International Criminal Court, international accountability for atrocities in Ukraine. That's important, but it's really only the starting point. And there's so many other important ways, complementary ways in which the abusers of rule of law principles need to be held accountable, whether it's in the court of public opinion, in history, in memorialization, and also reforms that make it possible for those kinds of abuses never to be committed again.
I have questions from the audience, so that means they have not been prepped for these, so who knows what they will be. Okay, partisan gerrymandering has been successfully challenged under state constitutions in Pennsylvania, North Carolina, and Ohio. Can you speak to the importance of state constitutions for protecting voting rights and democracy?
Sure. I mean, Raheem really said some important things there. I'll just build on what he has said, which is that what you're also seeing, because state courts have been have shown that they can defend rule of law principles, right? By which I mean that that electoral outcomes ought not depend upon the manipulation of voting rules or electoral lines. So I view that as a rule of law principle. It ought to be a function of the preferences of the voters without the people in power trying to do everything that they can to manipulate themselves to hold on to power. You are now seeing that those are becoming sites of important sites of contestation. So it's not just what the Constitution of the state says, but as we know as lawyers, it also depends on who is doing the interpretation, right? And so especially now that these state Supreme Courts have shown themselves to be the focus of these battles, then they're now becoming deeply contested, and part of what needs to happen is to figure out a way of shoring up and assuring that those who are doing the interpretation are interpreting their state constitutions consistent with the legitimate and good faith interpretations. We've also seen, by the way, some state Supreme Court justices who are identified with the Republican Party, who've done actually a great job of saying this is what our state constitutions say. And so it goes back to the point of how do we reinforce the fundamental values and rule of law values so that way that they are understood and interpreted in a way that's consistent with what the text actually says and not by the partisan proclivities of the interpreter.
Just a quick two-finger on that. I couldn't agree more. And I happened to be in Cleveland on May 3rd, Election Day, Ohio, of course, has had one of these cases and had an election where they didn't actually have agreed districts at that point because of the Supreme Court's upholding the rule of law and resisting a partisan gerrymandering. And it was a Republican Chief Justice of that Supreme Court who, really against personal interests and in the face of threats has really saved the day for the rule of law in Ohio. And I was giving a talk to the Cleveland Metropolitan Bar Association. They were about to honor her. And it seems like maybe a tokenistic thing, but it's actually really important for the people who take those difficult decisions, those rule of law decisions, to be celebrated and feel the support of their colleagues in the legal profession and beyond.
And I think we're going to see that this cycle. I know the North Carolina judges race is going to be very ugly, and I am personally concerned about the judges that actually did implement the rule of law being retaliated against. And again, that gets into kind of our discussion of where the courts go.
Can I add one piece to this,
Yes,
just as an
of course.
important observation? The Brennan Center has been doing great work documenting state legislatures that are essentially engaged in various forms of jurisdiction stripping and other activities meant to limit the ability of the courts to exercise independent judgment. And that's another thing that we need to keep an eye out for. It's one thing to participate in elections or participate in appointment processes, but in fact, if the state legislatures ultimately, as we've sometimes suggested should be done with regard to our state Supreme Court, do that to their state Supreme Courts, they become less robust protectors of the rule of law.
Betsy,
Ooh.
have there been countries that have experienced and emerged from horrendous events and found themselves a stronger democracy? How were they successful? What can we learn from them?
Yes, there are success stories, but again, it's almost never a straight line. What we see is often a kind of stutter step process with progress and then setbacks and then progress. Hopefully, it's 2 steps forward, 1 step back over time. But there are certainly some countries in Eastern Europe and the former Soviet Union that emerged from the Cold War, from the Soviet era without a lot of rule of law traditions there. That now Lithuania, Estonia, and Latvia all rank higher in our index than the United States at 30 years after the fall of the Soviet Union. So those are success stories for sure. There are other cases where countries have emerged from horrific conflict and seen slow but incremental progress. There is often a really complex set of things that have to happen in terms of accountability, reparations, memory, reform, guarantees of non-recurrence. There's a kind of a playbook of restorative justice that has been really important in cases where there have been kind of really horrific atrocities committed, and there's a lot of good literature on that some of which could be applicable here.
As we were talking earlier about the redistricting commissions, these redistricting commissions have reformed many of them from partisan to nonpartisan, and that's a great example of an infrastructure piece that can really make a difference. What other parts of election infrastructure, what parts of our government do we need to be looking to transition that can really help shore up our defenses? Open question.
Well, I'll share 2 that I'm focused on currently. One is the Electoral Count Act. I think the American Law Institute had a bipartisan commission that recently generated some principles for reform there that I think deserve some attention. Particularly thinking about the kind of January 6th scenario and how we can avoid that. That's worth looking at. Another less sexy area, but I think really important, certainly we see it in other countries around the world, is the importance of kind of independent audit agencies, the inspectors general, ombuds people in a lot of other countries. These can be really important, trusted voices of accountability that help navigate rule of law crises. And we've seen in this country the inspector general function under attack in the last administration, and really the independence of those bodies eroded in very concerning ways. And there's legislation pending now to reinforce the independence of those actors, make it much more difficult for an executive to dismiss inspectors general who are generating uncomfortable findings, and really to give those offices greater power. And I think those would be another set of important reforms.
If I can build on that and just bring up one question too about the Electoral Count Act. So the question for me is, how much can we do in terms of structural reform that is piecemeal without thinking of the broader whole that was brought up by things like For the People Act? So here's my worry about Electoral Count Act reform. In some respects, it's fighting the last war. So imagine a scenario in 2024 in which, maybe it comes down to Pennsylvania, and the governor or one of those contested states in which there's just a possibility of people who either believe in the big lie or believe that the state legislature can do whatever it wants in terms of the slate of electors. And then so they certify, so they decide not to pay attention to the results of the election in their state and says, no, the state legislature can do whatever it wants and we're going to certify our own slate. And then now that goes to Congress, and the Electoral Count Act has already been amended to say, hey, look, there's no role for anybody to play. You just have to essentially count the votes, right? Now you're in a crisis that, yes, the amendment responds to the prior crisis, but not thinking ahead as to what could possibly happen 2, 4, 8 years down the road, given the fact that the fundamental structure is still rickety. Right, you're still operating with an electoral college system. You're still operating in a system in which people don't really give effect to the right to vote. And I think that's a worry that I have in terms of the types of reforms that may need to be necessary. How much can we nibble around the edges, but how much do we really need to do, though recognizing the difficulty in a very polarized environment where there's fundamental disagreement on the right to vote and the role of the states even, that those types of reforms can't be done, but they might set us up for a future failure if we're thinking about the evolution of what these types of shenanigans can take place in the future, as opposed to the precise war that we just fought in the past.
I agree with both pieces and would add just a third. So the Alliance for Justice both focuses on courts and nonprofits, and to Professor Charles's very early point, I think we sometimes underestimate the extent to which our election system relies on a patchwork of civil government, not just government, civil society, not just government. And so it's often the case that some of the targets of these recent voter suppression laws are not always the voters themselves, but rather the nonprofits that work to ensure that they're registered to vote. The common example I give is that you can imagine that there is a homeless shelter, say in Texas, whose fundamental mission, of course, is to house the unhoused overnight, but who, as a byproduct of recognizing that people are unhoused, previously registered people to vote using the homeless shelter as a location at which it would do so, now finds itself under attack, and particularly having its fundamental mission challenged or undermined or put in jeopardy by virtue of its willingness to engage in civic activity more generally. That's happening all over the country in a variety of different ways, and something that we as lawyers can be attentive to. Nonprofits don't always recognize the extent to which they can engage in advocacy, but not just lobbying, but also voter registration, and those that do have been chilled to some extent by the spate of voter suppression laws that have been passed around the country. And so keep an eye out for local nonprofits of which you're a member, of which you're on the board, and asking, are you still participating in civic activities, or to the extent that they're not, engaging them as to why, and figuring out if you can come up with other alternatives and ways that they feel comfortable doing so, because that ensures, again, the rule of law, the greater participation of our fellow citizens in our democracy.
Yeah, I'm sure other people have experienced this, but being told when approaching an organization about, hey, would you like to be part of, registering voters? The response being, oh, we can't, we're not partisan. And how has registering voters become a partisan statement? I want people to be able to register is now somehow become a partisan statement, and that's really frightening.
Yeah, and that too was back to our origin story, if the Reagan administration launched several pernicious initiatives, one being packing the courts, the other was an idea of defunding the left. There was a broad concern that nonprofits in the country were predisposed to register people who were more likely to vote for Democrats, and so they attacked that. They weren't successful, but it did have a chilling effect, and that's how the Alliance for Justice's Boulder Advocacy Program came into being. And again, this, as I said, this recent spate of voter suppression laws is doing much the same. It's just the same old playbook rehearsed.
Kind of a little bit going back to the Electoral Count Act, but not really. How do we accomplish lasting protections when the Voting Rights Act and the Reconstruction Amendments have been chipped away? Even if we pass new legislation, how do we keep from getting right back to where we started? I think of Senator Manchin, who continues to say that he won't move on the filibuster because as soon as the Senate changes power, won't whatever new law that we enact to protect voting rights just be rescinded? So what's the response to that? How do we deal with that?
Sure. So a couple things. First is the recognition that formal law, and as lawyers we should be happy about this, really does matter. Like the 15th Amendment, even at the beginning of the 20th century, end of the 19th, state disenfranchising conventions really did matter. So yes, Alabama tried to undermine the 15th Amendment, but it had to try. It had to work really hard. And in many places, Alabama and Mississippi were successful, but there were other places in which it was harder because of the 15th Amendment. The 1965 Voting Rights Act really did make a lasting difference. And even though we don't have the protections of, say, Sections 4 and 5 now in certain types of states, it's actually that much harder to go back to 1965. We could talk all we want about the new Jim Crow, but the fact of the matter is the 65 Act fundamentally changed the baseline, and that's something that ought to be celebrated. So we may worry, and we ought to worry, about backsliding, but when we pass laws or when we amend the Constitution to protect fundamental rights, those things do change the baseline. And if you want to fight against it, you have to fight to move that baseline. And as you saw with the ACA, there is something to be said for the flip side of having a sclerotic institution, and that's what people worry about, right? Which is, look, once you get it in, it's not that, it's really hard you can try to chip away at it, but it actually becomes really hard to undermine it. It becomes hard to remove it. So for many years, the Republicans made it their mission to get rid of the ACA, and yes, they've made some progress, right? But the baseline has fundamentally changed. We're better off with it than would have been without it. So it is true that that we're going to fight, but moving the baseline, even incrementally, is fundamentally important, and that has long-lasting changes.
So I never like to finish off panels with depression because we all work in this space 24/7, and well, I do, and so I like to send us home with hope. So this is a question: how do we avoid despair when confronting large structural issues, especially when the structure is so hard to change?
I'm happy to start. It's things like this. It's community, always. I mean, that's probably what's been most difficult about the pandemic for me, and I'm sure for all of you. We have to be in each other's company. We have to make each other laugh. We have to enjoy the things that we're doing, because that's the only way to keep going through this process. I was always reminded, I went to Brown University, and a number of civil rights veterans taught there. And oftentimes at some point during the class, if we were talking about something difficult, one of them would break out into song. Just as a reminder that, there are humanizing elements that we have to incorporate into what we do, because this work is difficult, it is challenging. We often feel like we're on the losing end, particularly because we're trying to take us forward as others are trying to take us back. And so I'm just grateful to all of you. I needed to be here in order to enjoy your company, so thank you for coming out this morning.
Well, I'll add to that I think at the same time that we take on some of the big structural challenges or big fights and working kind of at the 1,000-foot level, I like to take to heart something Brian Stevenson says a lot, which is get proximate and find the smaller, more incremental local things to do. Roll up your sleeves, sign that poll worker pledge. Work in your organizations and leverage the institutions where you have networks, not just among lawyers, though those are important, of course, but workplaces, engage private sector neighborhoods, religious communities to support people in voting and defending their rights to vote.
Two quick things. So my students often ask me this question. And I tell them that when you look at the arc, right, it is long. But if you were sitting in say 50 or 45, and you were looking and you were thinking about the history of the United States, you would have been pessimistic, but would know that 1954 was right around the corner, 1964 was right around the corner, 1965 was right around the corner. Right? And what that means is that those things fundamentally change where we are as a country and where we're going. And I would rather be in 2022 than in 1945, than in 1866, than in 1953. And the reason is because people come together and they fight, they make the future better. And so even though there are moments in which it seems like there is despair, but 1954 comes, 1964 comes, 1965 comes, progress comes, and progress comes as a function of the work that people are doing today. So we can always be hopeful about tomorrow, notwithstanding where we find ourselves today.
And I'm not technically a panel member, but I will just say, for me personally, doing this work, I really do think of John Lewis. Where he started and where he finished. And thinking about if you had told John Lewis, as you said, when he's 20 years old, sitting at the counter, that he would be one of the most powerful people in Congress, and what he would witness throughout his life, would he have believed you? He might have hoped it to be true, but in that moment, would he have actually believed you? And that is, that is what he is who I look to, and it does help absolutely move forward. And I want to give you an opportunity. Does anybody have anything they would like to? Anything I haven't asked about? Something that I just missed.
You've been amazing.
Happy Pride.
Well,
Happy to end on a happy note.
Well, I want to thank my panel so much for being part of this presentation. And I will put out the final plug as a voting and elections director. Please sign up to be a poll worker. And if you're not a poll worker, go to protectthevote.net and sign up to be a poll watcher or a canvas watcher. We're going to need a lot of eyes and support this season and going further. So thank you.